2 for today's lecture. Apparently, the live stream of this class had way more audio feedback than intended. So this is the re-recorded version. The announcement that I stated at the beginning of class. For those of you that scored less than a 75 on the midterm and you want to try and recoup some of those points, you can continue to take the rest of the reading quizzes. So do the ones for Oval Office all the way through the end of the semester. And for each one that you complete, that's 1 point added to your midterm grade for a maximum of 9 points. So if you made less than a 75, you can take the rest of those reading quizzes and boost your grade up to not an 85, but to an 84, which is really good. Really, really good. Actually recoups your grade a lot. So perhaps you won't make an A in the class, but you will have a solid or a high B. So that's cool. And then for those of you that did not or have not been keeping up with your reading quizzes, so prior to the coronavirus and all this stuff, you have not been doing your assignments, have not been turning in your reading quizzes, or you haven't been doing well on your reading quizzes, I will still leave them up, and you will still have the opportunity to take them if you want to strengthen your reading quiz grade. Likewise, in terms of technology, I already sent a message via Blackboard, but I'll say it again here. So the way that I record these courses is that I use Zoom in order to have my nice little picture in the corner and to show and share the screen. I do this, and then I use encoding software that ultimately records everything that's on my computer screen, this experience right here, and then I upload all of this on YouTube. Sometimes I do great in being able to actually live stream this whole process, and then sometimes we have bad days. We know on Monday, YouTube pulled my stream. We didn't know that, can't stream copyrighted material. And also learn that if you have if you have a speaker on, or in my case, you forgot to turn off your Bluetooth speaker, it causes loops of feedback. Likewise, if you open a video or start your live stream on YouTube and forget to close the video after you end your stream, YouTube will continuously play videos. And even though I don't hear it and you may not hear it in the Zoom room, my computer, since it's recording everything on the screen, is actually recording the voice. So yeah, today was a clusterfuck. And for that, I apologize. This is why we're re-recording it again. But yes, I'm still re-recording with my Happy from Fairy Tale cape on. So here's the re-recording. If anything ever happens, like glitches, like what happened earlier today, what will end up happening is I just shut the live stream down, and that I will just continue to record the class exclusively with my encoding software and using the Zoom interface. And then after, when class is done, it takes a while to actually edit the video and upload it, but it's usually uploaded on the YouTube channel about 2 to 3 hours after the fact. And so, because my primary goal is to make sure that you all have access to the lecture materials. And then my secondary goal is to make sure that the live stream class experience is of great quality. But I will sacrifice that to make sure that the recorded lectures are of good quality. And so if you ever access the YouTube channel and you see there was a live stream and it was only like 5 minutes long, but now it's over, it's because I had glitches. And so I just shifted over. I usually try to send the link on Zoom, the Zoom link on the chat, so that way you can join. I'm still going back and forth between whether or not I want to pay for that subscription. But if I pay for it, I only have to do it for a month. So that actually may be worthwhile to just go on and do it. And then we don't even have to worry about YouTube because you can just join the Zoom and then I'll just put it on Facebook. We'll think about that. Anyways, back to what we're supposed to be doing at hand, talking about the court system. Lowe et al., Chapter 9. And so, of course, the courts serve the essential functions of settling disputes and interpreting the law. The most distinctive feature of the federal judiciary is its independence. It's separate from the other branches of government, And federal judges are appointed for life. Because judges have preferences about what the government should do, courts are inherently and fundamentally political institutions. While judges are in fact political actors, they are constrained by institutions and norms just like other political actors are. The main constraints are the Constitution and the laws, as well as common law, legal precedents, and the established judicial procedures. The key point here is that judges can't make whatever decision they would like to make. They are constrained by the Constitution, laws, precedents from precedents from previous cases, judicial procedures set in place by the courts themselves, and even norms of behavior established over time by previous judges. So let's talk about the categories of cases. The first one being criminal law. Criminal law deals with disputes or actions involving criminal penalties. So, not passing around the coronavirus, but actively going against laws like breaking the shelter in place mandate or curfews. That's criminal law. Civil law, it's a system of jurisprudence for settling disputes that don't involve criminal penalties. So just about every daytime trash court TV show is dealing with civil law. That boyfriend didn't pay you back, that's civil law. Someone hit your car, they didn't have insurance, civil law. And then finally, public law. These deal with cases involving the action of public agencies or officials. Did the FDA expose you to something or keep something hidden? Or did the state government you consider wrongfully seized your property? That's a case of public law. And then, of course, there are specialized courts for different types of cases. In Delaware and in another state, there is a burgeoning uh, fourth types of court cases dealing with business law. And so, once again, just to recap the types of law, criminal law deals with cases arising out of actions that violate laws protecting the health, safety, and morals of the community. The government in this case is always the plaintiff. For civil law, deals with not laws, law involving disputes between citizens or between a government and a citizen when there is no crime alleged. Two types of civil law are contract law and tort law. Contract cases are disputes that arise over voluntary actions. Tort cases are disputes that arise out of obligations inherent in social life. Negligence and slander are examples of tort law cases. So remember my hypothetical, of course, hypothetical class examples of, Rock Jones and the many, many hypothetical crimes that he did not commit, but using them to talk about what is negligence, libel, and slander. The cases that he would, the cases, the lawsuits that Rock Jones would raise against me would be examples of tort cases. And then finally, the third type of law, public law, refers to cases in which the powers of the government or the rights of the people are involved. The government in these cases is usually the defendant. Constitutional law involves judicial review on the basis of government's action in relation to specific clauses of the Constitution, as well as interpreted in Supreme Court cases. Administrative law involves disputes over the statutory authority, jurisdiction, or procedures of administrative agencies. So let's talk about the judicial process, in particular precedents and stare decisis. And so in addition to the law, the courts apply legal precedents, which are in fact prior cases whose principles are used by judges as the basis for their decisions in present cases. Stare decisis is the Latin term for let the decision stand. It's a judicial doctrine that a previous decision by the courts should apply as a precedent in similar cases until that decision is overruled. And so there are a variety of reasons why judges generally follow the doctrine of stare decisis. First, as a practical matter of public policy, if precedents were routinely overturned, the law would effectively not be fixed, and the judicial workload would be multiplied endlessly. Courts would continually be asked to reconsider the same issues over and over and over again, and political actors would never be quite sure how the court would rule on any particular case. Second, the credibility of judges as impartial interpreters of the law would be damaged if there was a perception that the meaning of the law was totally dependent upon the judge sitting on that particular case. Let's see. Thus, even when judges disagree on prior precedent, they are wary of overturning said precedent unless it is patently obvious that the precedent was wrong in the first place. And so an example of this would be back in 2000, the Supreme Court case of Dickerson versus the United States. Chief Justice Rehnquist effectively said that while he might want to overturn Miranda, he was loath to do so because the Miranda rights had become such an integral routine part of the police process, the arrest process. And he said whether or not we would agree with Miranda's reasoning and its resulting rule, we are blah, 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 blah. Were we addressing the issue in the first place, the principles of stare decisis weigh heavily in preventing overruling it now. And so let's talk about the organization of the court system. And so there are three types of courts. You have your trial court, your appellate court, and then you have your Supreme Court. Trial court is the first court to hear the criminal or civil case. Appellate court, that's the courts that hear the appeals of the trial court's decisions. And then finally, the Supreme Court is the highest court in the state or in the land/the nation, which hears cases on appeal. All three of these types of courts are functionally different and hierarchically organized. And so another way to think about this is that the trial courts are the courts where the facts of the case are generally discussed and determined. Appellate courts are where the problems, for instance, procedural issues from the trial court, can be taken up. And then finally, Supreme Courts are the places where final decisions on the statutory interpretation or procedures can finally be decided. So basically, for those of you that enjoy watching Law and Order or Law and Order SVU, in my case, trial courts, that's where all the nitty-gritty happens. Most of the cases that are heard on Law and Order take place in the trial courts. And so this is just a diagram showing exactly the structure of the U.S. court system. On the federal side, you have your U.S. district courts, then your Court of Appeals, then it goes up for requests for reviews, and then, of course, the Supreme Court. Meanwhile, on the state side, state trial, state appellate, state supreme, requests for reviews, and then we go up to the Supreme Court. Now, the Supreme Court hears less than 1% of the cases that are actually filed. It's like 0.01%. And we'll talk about that later on in the lecture. Why is that the case? So, as not stated, believe it or not, most cases are actually heard in the state's courts. Cases that are in fact heard in federal court are done so if they involve federal laws, treaties, or the Constitution. Article 3 of the Constitution gives the Supreme Court appellate jurisdiction in most federal cases, as well as gives Congress the power to create lower federal courts. And so the reason why most cases are heard in state courts is because it has to deal with cases requiring court action, so violation of criminal laws, etc. And so because these laws are created and enforced at the state and local level, of course, any violation of such needs to be heard in the court that corresponds with that type of violation. And so generally, cases that are heard in the federal courts deal with federal laws, treaties, or other nations, or with the U.S. Constitution. And so for the most part, Congress has assigned original and appellate jurisdiction to the federal courts on a geographic basis. There are 94 judicial districts, and then there are 11 regional appellate circuits, plus the DC circuit, so there are 12. There are also several specialized federal courts that have nationwide jurisdiction for particular kinds of cases. It's usually drugs and trafficking, higher level stuff of that sort. So let's talk about the caseload in federal courts. The caseload for federal courts has ballooned over recent decades to almost 500,000 cases a year. About 85% of these cases end in the district courts. Thousands of cases from the appellate courts are appealed to the Supreme Court every year. However, the Supreme Court dismisses 99.9% of these cases without ruling on the merits of that case. The Supreme Court has a broad latitude to choose which cases it will hear. And of course, over the last 5 years, the court has only given a full hearing to less than 90 cases each year. So very, 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 very few cases. I'd imagine for this session of the Supreme Court, they probably would hear less than 50, maybe even less than 20 cases as a result of the coronavirus. And because, especially since everybody on the Supreme Court is a high risk to actually catching and suffering complications from the coronavirus. So let's talk about these federal trial and appellate courts. Let's see, district judges are assigned on the basis of workload. The busiest federal district court has 28 judges. Circuit courts of appeal have between 3 and 28 permanent judgeships, and it depends on the workload. The Central District of California is the largest federal district by population. It includes all 5 counties that make up the greater LA area. By contrast, New York City and the surrounding metropolitan areas are divided between the Southern District of New York, which includes Manhattan, the Bronx, and Westchester County, and then the Eastern District of New York, which includes Brooklyn, Queens, Staten Island, Nassau County, and Suffolk County. New York suburbs in Connecticut as well as in New Jersey are covered by the District of Connecticut and the District of New Jersey, respectively. The Southern District of New York and the Central District of California are the largest federal districts by the number of judges. New York, the Southern District of New York has 28, and the Central District of California has 27 judges. The busiest court district in terms of criminal federal felony filings. Woo! Criminal federal felony filings was the District of New Mexico, followed by the Western District of Texas, then the Southern District of Texas, and then finally the District of Arizona. These 4 districts share a border with Mexico. And so, as a result of a crackdown on illegal immigration, it resulted in 75% of the criminal cases being filed within the districts in 2007, being filed in those 4 districts and the other districts as well that are bordered with Mexico. And so the busiest patent litigation court is the busiest patent litigation court of all the federal districts is the Eastern District of Texas, with the most patent lawsuits being filed there nearly every year. So everybody that has a new invention and wants to secure patents on it, for some reason, majority of them are being done in the Eastern District of Texas. What does that mean? I don't know, but if you have a great idea for a new invention, you may want to just go on and file that patent work in the Eastern District of Texas. And so what about the Supreme Court? Of course, Article 3 states that the judicial power of the United States shall be vested in one Supreme Court. By law, the Supreme Court has 1 Chief Justice and 8 Associate Justices. The Chief Justice presides over the court's public sessions, and he gets to speak first during deliberations and then also gets to vote very last. While the Chief Justice does not have any additional constitutional power over the other justices, the Chief Justice does in fact have some opportunities to influence the direction of the court based on his or her ability to shape the decisions by the way it presides over the public sessions, by the way he or she speaks first through deliberations, and could also serve as a tiebreaker when he or she gets to vote very last. And so how are judges appointed? The president nominates the federal judges and then the Senate confirms. With that in mind, we have this concept of senatorial courtesy, and that is just before a person is nominated for a federal judgeship, the president finds out whether the candidate's home state senators support the nomination. So let's say that, since I still claim Georgia, for some reason President Trump wants to nominate me to be a federal judge. To do so, he would, prior to doing so, he would ask my home senators. I believe one is a Purdue and the other one's Johnny Isakson. I don't think he's stepped down yet. I know he's not running for re-election. But he would ask them what they thought about me and whether or not they would support my nomination. If they do, great, then, full steam ahead. And if not, well, of course, the president would find out why or why not the senators don't support, my potential nomination. And then if the reasoning is valid, the president could choose to abandon me and pick another person, or could determine that their reasonings to be invalid and then continue onward with the nomination. But prior to nominating a person, the president would ask the home senators what they thought about said person. Hence the courtesy. And so let's talk about the Supreme Court appointments. Since the 50s, nominees to the Supreme Court have been questioned in depth by the Senate Judiciary Committee. Recent nomination fights have been intensely ideological, even to an extent extremely polarized. Presidents have instead turned more and more to sitting appellate federal court judges who have proven records that can be read and reviewed. Presidents have turned more and more to former federal judges rather than to politicians, private attorneys, and law professors to serve on the Supreme Court. Some scholars argue this is the case because former federal judges have clear records established over many years that prove to be reliable predictors of future behavior on the bench. However, that's not necessarily the case all the time. Former Supreme Court Justice David Souter is actually an example of a nominee who turned out to be far more liberal than President H.W. Bush, so Daddy Bush, and his allies in Congress wanted. The only person on the current court that was not a former federal judge is Elena Kagan. As a former Obama administration appointee, she was the Solicitor General. It could be argued that Obama knew her ideological leanings well despite her lack of judicial experience. When Obama nominated a moderate federal judge, Merrick Garland, to fill the seat vacated by the passing of Justice Scalia, Senate Republicans vowed not even to hold hearings on the nomination, and then actually followed through on that threat in 2016. And so this is the list of all the justices on the current iteration of the Supreme Court. You usually identify the Supreme Court by the last name of the Chief Justice. So right now we're still hanging out in the Roberts Court because John Roberts is the Chief Justice. Who has been on the Supreme Court the longest? Clarence Thomas. Clarence Thomas has been on the bench as a Supreme Court Justice for 29 years. Followed then by RBG, then Breyer. Who is the oldest person on the Supreme Court? That would be RBG. The youngest? Gorsuch, born in 1967. Gorsuch is the youngest. And so in terms of the diversity of federal judges, we can see the number of female, African American, and Hispanic judges appointed via the various presidential administrations. So Obama has appointed the largest number of female judges. Meanwhile, Clinton and Obama have appointed the largest number of African American federal judges. And then finally, Obama has appointed the largest number of Hispanic federal judges. And so this is where we will stop for today and pick back up on Monday, talking about the courts as political institutions. There are three roles for the courts in the political system, to talk about dispute resolution, coordination, and then interpreting the rules. So what do we mean by, resolving disputes? It's talking about fact finding and judgment. Coordination refers to providing before the fact incentives as well as disincentives for behavior. And then finally, for rule interpretation, it's just filling in the gaps in the law. And with these three roles, this demonstrates the institution principle at work. And so we will pick up here on Monday. Enjoy the rest of your weekend.